Well, good morning, ladies and gentlemen. Thank you very much for that introduction. An enormous pleasure to be here. And I have a presentation on trade associations and the exchange of information. And in a sense, it seems to me there are two different talks that I could give. One about the role and the functions of trade associations, and secondly, about the extent to which the exchange of information between competitors, including sometimes through the medium of a trade association, in what circumstances can that give rise to problems in competition law. So I shall divide my comments between the two different topics. To begin with the subject of trade associations themselves, I think it's very important to begin with the obvious point that trade associations perform many very valuable functions for society generally, for industry, and for the consuming public. And so it would be quite wrong in any sense to demonize trade associations in competition law terms, because we have to recognize the many good and beneficial things that they can do. And I've listed here a few of those things. Obviously, trade associations represent the interests of their members during the legislative process. Trade associations very often can be helpful to the government. If the government has a particular policy which it doesn't necessarily wish to put into practice through legislation, it may well be that a government can negotiate with a trade association, and the trade association may be helpful to the government in pursuit of particular legitimate aims. Many trade associations take a role in the establishment of industry standards, and in many circumstances the setting of standards is beneficial and the public benefit from those standards. Trade associations can be very important in establishing trade fairs, annual exhibitions, and so on and so forth, where consumers and manufacturers come together. Thank you very much. And one additional point that occurred to me after I prepared this slide is that trade associations can help the whole process of benchmarking, because benchmarking is a very important function and is something that can enable undertakings to test the efficiency of their own organization when compared with that of others. However, having said that, we ought to recognize that trade associations can be problematic insofar as they act as a medium for the entry into cartels on the part of the members of the association. And this is a well-recognized phenomenon. Just when I was preparing for this talk today, I had a quick look to see internationally what has been going on in relation to trade associations in the last few months. And instantly, I came across a whole series of cases in different jurisdictions where we find the same sort of pattern, in particular where a trade association either recommends price increases to its members, or in some circumstances, depending on the constitution of the trade association, it might actually mandate the prices at which members will sell their goods or services. And so just randomly, here are a few examples. Last week, the Competition Commission in Singapore issued a decision in which it said that the fact that the Singapore Medical Association gave guidance to medical practitioners as to the fees that they should charge for their services, that involved an infringement of Section 34 of the Singaporean Competition Act. I found 4 examples in Spain in the last few months where trade associations were involved in the recommendation or the fixing of prices for iron warehousing, Jerez, sherry, several food industry examples, and a specific example in relation to bread. In Switzerland, the Swiss Competition Authority has started looking into the way in which fees are charged for the sale and purchase of real estate, where there are recommended fees. There's a case on private laboratory services currently in Sweden. And when I arrived here this morning and I was introduced to the translators who are speaking to some of you now, I was told that until 20 years ago, the International Association of Translators in Geneva used to fix the fees for simultaneous translation. And apparently that practice was brought to an end when some translators were working in the United States, and the Department of Justice heard that the prices that they were charging had been fixed by an international trade association. So this just shows how live and real this subject is. The last bullet point refers to standards. I said earlier that as a general proposition, the setting of standards can be a good thing, and trade associations can be helpful in setting standards. But of course, sometimes standards are set in a deliberate way to act as a barrier to entry to keep competitors out of a market. And so sometimes competition authorities have to look at the way in which the standards are being set to determine whether this is a pro or an anti-competitive phenomenon. Now, an interesting thing about trade associations is how does the legal system, whether it's the legal system of Europe or the US or Chile or Singapore, how is the phenomenon of trade associations actually addressed in the primary legislation? And it is quite an interesting point when I came to look at your own law, which is that some legal systems explicitly address the phenomenon of trade associations. And many of you here will be familiar with Article 101 of European Union competition law, which specifically prohibits agreements between undertakings, concerted practices between undertakings, and decisions by associations of undertakings. So there we find that the primary legislation specifically acknowledges and anticipates that recommendations or mandatory instructions from trade associations can be anti-competitive, and so the law specifically addresses decisions by associations. That's the European model, and the European model has been followed in many legal systems in the world. All 27 member states of the EU have this expression, decisions by associations of undertakings. The Singaporean legislation does, the Malaysian legislation adopted in April of this year does, the Hong Kong legislation that will be adopted next year does. So many systems explicitly acknowledge the problem of trade associations. Some, however, do not. The Indian Competition Act does not have a specific provision on trade associations, and as I read your legislation, there's no specific provision either. The question is whether there is an agreement between undertakings. So insofar as legislation does not specifically provide for the possible problem of trade associations, one is therefore required just to think through what is meant by an agreement or a concerted practice between undertakings. And obviously it is at least possible in law to reach the conclusion that an instruction or a recommendation by an association to its members leads to an agreement or concerted practice between the members. But that's quite a difficult piece of legal reasoning to apply. As I say there, I think every case is going to be highly fact-specific. You might have one situation in which the constitution of the trade association says that if the association makes a recommendation to its members, that the members are obliged to comply with the recommendation. Well, then I think it's quite easy to see that there's an express or an implied horizontal agreement between the members to comply with the instruction from the association. If, however, the constitution is looser than that, or indeed doesn't have any reference to this phenomenon whatsoever, then I suppose the competition authority has to work somewhat harder to detect and establish the existence of an agreement or a concerted practice between the members. As I say, it's going to be fact-specific. It's an empirical exercise. To my mind, however, if a trade association does make recommendations to members, I think there's a fairly strong presumption that the likelihood is that the members will comply with the recommendation. So at the very least, I would say there is danger for the association and the members where this kind of phenomenon is taking place. So those are some comments on trade associations themselves. But if I then move on to the second bit of the title of the talk, what about